Hey guys, and welcome to the weekly Docket. We'll travel around the U.S. like a Chinese spy balloon, checking on developments and interesting cases. This week we'll travel to Wisconsin, South Carolina, Indiana, Idaho, and finish with a national story. Let's start in Wisconsin with a story of Taylor Schabusiness, accused of decapitating and dismembering her lover. I'd hate to be her enemy. Client satisfaction is important in an attorney-client relationship, and so is clear communication. Well, when the judge said the trial would be moved to May, this date apparently was not what Miss Schabusiness wanted to hear, and she communicated her dissatisfaction very clearly by attacking her attorney in the courtroom. Let's watch.
15 for the trial.
Stop it.
Now, I understand the attorney has asked the judge to withdraw. I didn't see it in the docket yet, but I did see that reported. Well, how can you keep your head on a swivel for your client when you know they'd like to literally put your head on a swivel? Can you advocate for someone who might attack you at any moment again? Someone who chopped off her boyfriend's head, dismembered him, and told the police she liked it, and good luck finding all the parts. I get she's trying to show she's incompetent to stand trial, and on that she gets an A for effort, but an E for evil. Now let's head to Indiana in the case of Richard Allen, who has been arrested for the felony murder charge of Abby Williams and Liberty German. Remember when the state said after they arrested him, they needed to keep his probable cause affidavit sealed because of their investigation and the possible involvement of other parties? But then when it was revealed it supported the defense contention, it didn't even reference any other party? Yeah. Still no indication that I've seen that they're planning to arrest anyone else or have any evidence tying Richard Allen to anyone else. We've already gone over the evidence, which is basically timeline and the shell casing, whether you like it or not. That's it. It's pretty thin on the physical evidence so far, at least. The timeline looks pretty strong for the state. Current status is discovery's going on between the parties. The defendant is trying to arrange a hearing so he can get bail set. I don't think he's going to succeed on that one. And the media is asking for the gag order to be changed. Now let's head to South Carolina and take a look at the Murdaugh case. There are some questions in this case that may never be answered. Like, is it Murdaugh, Murdaugh, Alec? Why do they keep pronouncing this guy's name so many different ways? I don't know. But the main point is, did he commit murder or not? So this case for this week started out with losing 2 jurors to COVID. And then the attorneys asked for a delay. The judge wasn't having any of that and said, if you want to wear a mask, wear it. Defense counsel wore a mask for a few minutes to indicate his concern over COVID. But then when the judge said we're going to move on anyway, apparently the COVID danger dissipated and the mask came back off. So we heard this week the lead investigator testifying he didn't know for months that the t-shirt had tested negative for blood. It's not good for the state. He had testified, I think, to the grand jury that it had blood on it. But how could he know that? They didn't have a test for that. He also testified that he had lied to he tricked Murdaugh about the shotgun loads because he's allowed to trick someone to elicit a response. Okay, that's true. And when I heard it, I thought, okay, because he's saying all the other shotguns found at the residence had loads in them similar to what was used for the murder, except for the shotgun that Murdaugh showed up at the 911 call with next to his truck, which had a different load in it. So he was trying to get Murdaugh basically to say, yeah, okay, those are the loads. Why is this different? I don't know why he chose to do that. It's not such an important fact by itself, maybe, if it were true, but it was untrue. But what's worse is the defense attorney got him to essentially admit that he misguided the grand jury on that as well, because it just wasn't true. So not good for the state. Defense team, in my opinion, scored more points showing how the state dragged on searching the grounds of Alex's mother's house than the late-breaking GPS evidence that's going to come in that shows that he didn't have a detour. At least that's what they say. So he didn't go down some weird side road to throw away evidence. And he didn't ask the investigator, Murdaugh, for the clothes he had on before he changed the night of the murder. He's never asked for that, apparently. The state tried to rehabilitate by saying, well, he didn't suggest that he bring the clothes over. He didn't suggest quicker searches and things. But in my opinion, the defense won that one by saying, do you typically rely on suspects to tell you which evidence to collect. The state scored some momentum back with the judge ruling it can now bring in evidence of Murdaugh being shot and having lied to the police about it. And some people think, well, that's not really that important, but I think it is, because here's an attempted murder. He gets shot in the head, and he calls the police, and even though he's the victim of it, he's telling the police someone shot him, he was just changing his tire, but all that's a lie. He had arranged it. He knew who shot him. He lied on the 911 call. He lied to the first responders, and he even met with a sketch artist to create a sketch of someone who didn't exist to further this false story. So this shows that he's ready and able to mount a convincing story from the 911 call forward up until he's meeting with investigators to lie about attempted murders. That's not a good look for him. So now yesterday was some time spent on, Thursday was time spent on how the shooter must have been standing or not when he fired the second shot at Paul. Was he crouched over? Was he leaning? Was he really short? Was he down on one? Or they never said, was he down on one knee, which I think is odd because I've shot a lot of rounds down on one knee. But maybe he fell back, was leaning over. I don't know. If this was all meant by the defense to say the father couldn't have fired the shot, then I think it's just silly. I mean, he could have. He's not that tall. He's not some NBA basketball center or whatever. He easily could have held the shotgun low enough, leaned over, down on a knee, crouched, whatever, and fired this shot. And so could someone else, but it wouldn't have been impossible for him to do it. I wasn't impressed by that. Today should see the wrap up of all that, and maybe the GPS guy to finally say what they found on the truck, which I don't think is going to change the case a lot, except it might reduce speculation, certainly that at least that I had, that he might have taken a detour somewhere to dispose of this evidence. So if he did have evidence and did dispose of it, and it does show him going straight to his mother's house, then he must have left it there to begin with, I suppose. And then the belief is the state will rest then or shortly thereafter unless they have a surprise witness. But we don't know that, or it wouldn't be a surprise, but probably not. So in my opinion, this is by no means some kind of open and shut solid case. It's a baffling aspect to me because of my firearms history, which is why the change in firearms? It takes time. Why would you do it? You're shooting one person with a shotgun and then the other person with a rifle, and that doesn't make any sense to do that. Why would you do that? Now, and even how could you do it and the people be in such close proximity? Like, why would you come prepared with two different guns and then switch in the middle of them? I don't know that. To me, it only makes sense in the absence of evidence. If one person was shot and then the other person was lured down there and then was also shot. So maybe you shot the first person, you leave the weapon there and you go up and you get this other weapon to say, let's go check out what happened. And then you shoot the other person. I'm just making that up because I don't know. But what I do think is that for a single person to be switching weapons in the middle of a double murder, it's very bizarre. So either he did it, okay, he killed two members of his family, or if he participated in it, there was a second shooter and he was one of them. He did it with someone else. Or he arranged it and one or two people, or perhaps more, committed these murders based on what he had asked to be done. Since he has done that since then, it's possible. He and his son perhaps brought it on by their illicit behavior. But he thought it was because of his son's involvement in this boating case, right? And then, of course, he has his own drug situation and stealing lots of money and stuff. People have been killed for far less money than he was stealing. Or it's just a random murder, which seems pretty unlikely. So my opinion on all this is he did it. He did it. I don't find those other things compelling. The first one, he should go to jail. The second one, he should go to jail. The third one, I don't know that it meets the charges, but he should be in jail. So I don't know. The motive is something that's missing for me. If he did try to have himself killed, I saw a comment and I agree with it, and then perhaps this was a blown murder-suicide. Maybe he even intended to die that night and he just didn't. Whether he was going to do it himself or the people that he had doing this, he didn't let them do it or something. I don't know. That would end the seemingly bottomless pit of problems his family faced and maybe pass life insurance on himself to his remaining son without the liabilities and drama tsunami that was washing down over them. I don't know. Motive isn't required, of course. It just helps illuminate the evidence in the narrative. Is it established beyond a reasonable doubt that he's the killer? The case presentation so far seems disjointed at times, going from here to there, but it isn't over yet. The defense gets to present their case, and then attorneys try to bring it all together in a closing argument, and they could have a strong narrative for the state that realigns the evidence and makes it clear that he's the guy who did it. You've heard all this testimony over weeks, but let's get down to the essential points. He's the guy. The defense will try and poke holes in that, I think, certainly with the second shooter scenario and maybe some other things too. So we'll keep an eye on this crazy drama. Even if he gets off on this murder charge, the financial crimes he is guilty of. So he's going to go to jail forever. He's not going to not go to jail, even if he gets away with this. So assuming he's the one who did it. Now let's head out west to Idaho in the case of Bryan Kohberger, who's charged with the mass murder of 4 college students. There's still a little dust up on the gag order out there. It's fairly limited, but it's poorly understood, even though it's short and pretty clear. People seem to think it keeps the families from speaking, but it doesn't. It just keeps their attorneys from speaking, and it's the attorney who's filed the motion for this, along with the media, who generally oppose these type of orders, obviously, because they want to get access to information. But it sure looks like they have the right guy. With the gag order in place and there's limited leaks and limited information, the void in social media is kind of filled with speculation. And there are some people who, for example, take this sheath that even if it has Kohberger's DNA on it, they're like, oh no, that doesn't prove anything. He could have given that to someone else and he put it there. Or maybe it was planted to frame him. Or maybe it was dropped down the chimney by a Chinese spy balloon. If that sheath has his DNA on it, which they say it does, his goose is essentially cooked. And there's also an increasingly strong circumstantial case around the guy. People have also decided to attack the defense attorney, and all she's done so far is show up to court and be professional. The theoretical conflicts of interest and also a lot of complaints online about her rate, $200 per hour. Did they bother to read the agreement between the counties? The county that she comes from gets paid the $200 an hour, and if she works overtime, she gets $200 an hour. So how much of the 200 is the county giving her for her regular hours, given that she's already employed by them? Don't know. Also, the agreement calls for her to have support staff and to pay for those out of the rate that she gets. So she's pretty much costing less than an HVAC tech that you would call out to your house. That is way outrageous for a death penalty case, right? No, it's not. People just like to complain about this because they hate Kohberger, which I do understand. He's entitled to good representation and he should get it. But social media is what it is, and people are going to attack other people. It's just what they do on social media. Let's stay in Idaho and talk about the terrible case of Chad Daybell and Lori Vallow and the murder of 2 of her children. Chad Daybell's case is headed to trial potentially in April. It did get moved from its original county due to publicity. The state requested the jury be sequestered, but the judge agreed with the defense in this case and said we don't need to do that and denied the state's motion. So I think he asked for the case to be continued and the judge said no. So he's wanting it to go slower. On the flip side, she's wanting it to go faster. So Lori Vallow vacillates from claiming she's too nuts to attend trial, and she was successful for a while with that, to maybe being too nuts to attend trial, and potentially, look what she's done, to complaining the trial is taking too long and should be dismissed for failure to provide a speedy trial. The state counters her murder indictment is only responsible for part of her incarceration time, so her trying to count time back for that shouldn't count against the state, and that she would have been tried in January except for her own incompetence to stand trial. And when she was found incompetent, the case was delayed. It lost its January docket, and so it was moved out a few months. And the court says, look, that's how it is. You haven't really had any material delay at all. But imagine thinking, I think some people did, that this horrifying murderer was going to walk free out of the courthouse just because it takes some time to get her to trial on a complicated case that has venue concerns. And the case, of course, moved while they deal with the publicity of that and her own competence to stand trial. So some advice there would be, if you're kind of nuts and you don't want to spend a lot of time waiting for a trial, don't participate in the murder of children is a great way to avoid it. It's not foolproof, but it's a good start. And don't count on the court to sit there and go, well, here's a technical rule. I'll just construe it in your favor. And although you're a violent murderer, I'll just let you go free. It's unlikely to happen. There are lots of exceptions to the speedy trial stuff. And this case has not taken too long. It's not even remotely approaching that. However, the defense team needs to try it. The judge ruled on it and said, nope, you're not going to walk free for this. You need to stand trial. And that happened this week. Let's finish with a case of national interest, the Jeffrey Epstein case. Not whether he committed suicide or not. I think you know the circumstances around that, and you believe what you want to believe on that one. But it's hard to see this Epstein case as anything other than powerful people being protected while they're trafficking and abusing children and young women. Really? I mean, that's just what this is. And no one else held to account for it besides him and Maxwell. So that's awful. The argument is, will his client list be released? What was released this week were some emails between Epstein and a principal or executive at a finance organization describing these girls as Disney princess characters and how much fun they are and which character they're going to get next. Disgusting. It's absolutely disgusting. And the people who participated in this with Epstein should be brought to justice. There shouldn't be a private jet, private island exclusion to bringing these people to justice. And our law enforcement agencies need to make that happen. This guy was protected way too long, way too long. The justice system needs to work here, and not to slander people, but for the people who were involved in this, do something about it. So that's the weekly docket, and I hope everybody has a good weekend. Thanks, bye.